About 12 hours after President Donald Trump started this new war with Iran, his FBI director, Kash Patel, took to social media to reassure the American public about safety here at home. He said, quote, "Last night I instructed our counterterrorism and intelligence teams to be on high alert and mobilize all assisting security assets needed. While the military handles force protection overseas, the FBI remains at the forefront of deterring attacks here at home." At the forefront, he says, at the forefront. That is the idea. That said, new reporting from MS Now's Carol Leonnig tonight says this, quote, "When FBI Director Kash Patel fired a dozen FBI agents and staff last week, he targeted an elite counter-espionage unit that investigates threats from foreign adversaries and specializes in Iran." According to more than a half dozen sources with knowledge of the firings, the unit that Patel gutted, known as CI-12.
What's up, guys? Adam is here. The courtroom doors slammed shut and Mike Patel's world collapsed. One minute he was standing in front of a federal judge. The next minute he was staring at the business end of a contempt order that could put him behind bars before sunset. This wasn't a warning. This wasn't a threat. This was a judge looking directly at one of Donald Trump's most loyal allies and saying, "You will answer my questions, or you will answer to the marshals."
Did you see the President of the United States declassify the documents that were found at Mar-a-Lago?
I witnessed the President of the United States issue a declassification order for documents.
That did not answer my question. Did you or did you not see the President of the United States declassify the documents that he was holding, the classified documents that were at Mar-a-Lago? And did you?
I don't know the answer to that question because I don't know what was fully found because the Justice Department hasn't made that public.
You claim publicly that you saw President Trump declassify documents. Is that correct?
That's correct, Senator.
So you did indeed see President Trump declassify the documents that were found at Mar-a-Lago that he refused to turn over. Is that correct?
No, what I said, Senator, was I heard and witnessed the President issue a declassification order for a number of documents.
For the documents specifically that were at Mar-a-Lago?
When he issued that order, there was documents. I don't know what was found and what was not found at Mar-a-Lago. I wasn't there.
And when the hearing ended, the word spread through the courthouse like wildfire. Patel just got boxed in by immunity, and if he steps 1 inch out of line, there's a cell waiting for him with his name on it. Let me tell you something about what just happened, because the videos you've been seeing on YouTube with titles like Kash Patel crumbles as judge delivers final warning before jail and Patel faces prison guarantee have millions of views.
What does CI-12 do?
CI-12 is casually known, that's its kind of code name, but it's casually known as a global espionage squad of the FBI. It's got a combination of agents, analysts, and also support staff based out of the Washington field office. It's been involved in a really interesting panorama of cases, Rachel, some of which you've covered extensively here. It worked on the case involving classified documents involving Donald Trump, hoarding and concealing hundreds and hundreds of top secret records at his home in Mar-a-Lago. It also investigated leak investigations. It investigated John Bolton even, and classified records that were found at his home, or classified information, forgive me, that was found at his home. And it also, with the exception of Russia and China, looks at espionage and other threat information from foreign adversaries in other countries.
They show dramatic courtroom meltdowns, screaming matches with judges, marshals dragging people away in handcuffs, and every single one of those videos has a tiny disclaimer buried in the description that says, "This content is fictional and not intended to represent real events." But here's the thing. The reason those videos go viral is because the real situation is so explosive that the fictional versions don't feel fake. They feel like previews. Because in reality, Kash Patel just got dragged through a legal ringer that left him with nowhere to hide. He was subpoenaed to testify before a grand jury in the Trump classified documents case. He tried to take the Fifth Amendment, which is his constitutional right to refuse to answer questions that might incriminate him. And prosecutors looked at that and said, "Nice try." They went to a judge and got an immunity order, and once that immunity order was signed, Patel's Fifth Amendment protection evaporated like morning fog. He could no longer refuse to answer. He could no longer hide behind the Constitution. He had to testify, or he would be held in contempt and thrown in jail until he did. Let me walk you through exactly how immunity works, because this is the part that should terrify every single person in Trump's orbit who thinks they can just clam up and wait for the investigations to blow over. The Fifth Amendment protects you from being forced to testify against yourself. It's a fundamental right. You cannot be compelled to be a witness against yourself in a criminal case. But prosecutors have a tool to overcome that protection when they need your testimony to build a case against someone else. It's called use immunity, and what it means is this. The government agrees that your testimony and anything derived from your testimony cannot be used against you in a criminal prosecution. In exchange, you lose the right to remain silent. You have to testify, you have to answer every question, and if you refuse, you're not protected by the Fifth anymore because the immunity order eliminated the self-incrimination risk. Refusing to testify after immunity is contempt of court, plain and simple, and contempt can mean jail. So Patel walked into that grand jury room with immunity in his pocket and a target on his back. The man who spent months on television defending Trump, making sweeping claims about declassification, and attacking the FBI as corrupt was now under oath. Every word he said was being recorded. Every answer was being compared to documents, to other witness statements, to his own public comments. And if anything he said contradicted what he'd said on TV or what the evidence showed, he wasn't just embarrassing himself. He was committing perjury, which is a federal felony carrying up to 5 years in prison for every single false statement. And here's where the trembling evidence comes in. Patel has made some incredibly bold public claims over the years. He said he personally witnessed Trump declassify whole sets of documents. He's claimed that the Russia investigation was a setup based on fabricated evidence. He's suggested that the FBI planted evidence and spied on the Trump campaign. Those claims made him a hero to the MAGA base. They got him booked on every conservative media show. They built his reputation as a fighter who wouldn't back down. But now those same claims are evidence that prosecutors can use against him. Because when he sat in that grand jury room under oath, prosecutors asked him about every single one of those public statements. They asked him, "Did you actually witness declassification? When did it happen? What documents were involved? Who else was present? Was there any paperwork?" And if his answers in the grand jury didn't match what he said on television, prosecutors now have a perjury case ready to go. Let me read you something from a detailed legal analysis that ran in Lawfare about Patel's situation. The article notes that Patel has made sweeping public claims about Trump declassifying documents and about Russiagate materials being improperly handled by intelligence agencies. And those claims were cited by the FBI when they sought the warrant to search Mar-a-Lago for classified documents. So Patel's own words helped establish probable cause for the search that Trump supporters have spent years calling illegal, and now those same words are being used to box him in under oath. Legal commentators have been very clear about what this means. If Patel, now a high-ranking official in Trump's administration with significant power and influence, willfully disobeys court orders or lies under immunity while testifying about material facts, judges can escalate from warnings to civil or criminal contempt. Civil contempt means you sit in jail until you comply with the order. Criminal contempt means you serve a fixed sentence as punishment for defying the court. And perjury means you go to prison for lying. There's no escape hatch. There's no political connection that can override a federal judge's contempt power. When a judge says testify or go to jail, you testify or you go to jail. Period. The phrase faces jail fits the genuine legal stakes perfectly because under immunity, Patel no longer gets to hide behind the Fifth Amendment. So if he stonewalls investigators or lies under oath about material facts related to Trump's document handling, Contempt or perjury charges are real risks that could land him behind bars for months or even years, depending on the severity of the misconduct and whether judges view it as willful defiance of court authority. The trembling evidence concept works as a way to describe how Patel's own prior statements, memos, and public claims can now be turned against him in court, with judges and prosecutors comparing his old rhetoric to his sworn answers and catching him in contradictions that could form the basis for perjury charges carrying serious prison time. Now let's talk about what this means for the rest of Trump's orbit, because Patel is not just some random guy who wandered into a courtroom. He's a test case. He's the experiment that shows what happens when a fiercely loyal ally gets boxed in by immunity and the threat of contempt. And other insiders are watching his situation very, very closely. They're watching to see whether Patel's legal strategy works, whether he can thread the needle between protecting Trump and avoiding perjury, whether judges actually follow through on their threats, or whether they blink when faced with a high-profile defendant. And the results of that experiment are going to determine how every other Trump ally behaves when they get their own subpoenas. Because here's the thing about loyalty in Trump world. It's great for television, it's great for rallies, it's great for book deals and speaking fees. But when you're sitting in a grand jury room with an immunity order in your file and a prosecutor asking questions you don't want to answer, loyalty doesn't keep you out of jail. Contempt doesn't care how many times you defended the president on Fox News. Perjury doesn't care how many standing ovations you got at CPAC. The only thing that matters is what comes out of your mouth under oath and whether it matches what the evidence shows actually happened. Patel's public claims about declassification are particularly dangerous for him now because they're so specific and so well documented. He went on television and said Trump had a standing order that any documents taken from the Oval Office to the residence were automatically declassified. He said he witnessed this. He said it was standard procedure. Those are factual claims. They can be proven true or false. And other witnesses have already testified that no such standing order existed, that declassification requires paperwork and notification to intelligence agencies, and that nothing like what Patel described ever happened. So if Patel testified in the grand jury that he did witness such an order, prosecutors have multiple witnesses ready to contradict him. If he testified that he didn't witness it, prosecutors have his television appearances ready to impeach his credibility and potentially charge him with perjury for lying under oath about material facts. The Russiagate claims are equally problematic. Patel has spent years claiming that the FBI investigation into Trump's campaign was a baseless witch hunt built on fabricated evidence. He suggested that intelligence agencies spied on Trump and planted informants to destroy his presidency. Those claims made him a hero to the base, but they also created a paper trail that prosecutors can now use against him. Because if Patel had any evidence to support those claims, he would have been legally required to produce it during the investigation. If he didn't have evidence, then his public statements were false. And if those false statements influenced the investigation or were repeated to federal agents, they could form the basis for false statement charges under 18 U.S.C. 101, which carries up to 5 years in prison. The FBI cited some of Patel's statements when seeking the warrant to search Mar-a-Lago. Think about that for a second. Patel's own words, the words he used to defend Trump and attack the FBI, were actually used by the FBI to justify searching Trump's home. That's the kind of irony that would be funny if the stakes weren't so high. Patel created a public record that investigators used against his own boss. And now that same public record is being used against him personally to box in his testimony and potentially set up perjury charges. Let me break down the legal mechanics of how this could actually land Patel in jail. Under federal law, perjury requires proving that someone made a false statement under oath, that they knew it was false at the time, and that the false statement was material to the proceeding. Material means it could have influenced the outcome or the investigation. In a grand jury investigating Trump's document handling, almost anything Patel says about declassification, about document storage, about conversations with Trump, about knowledge of classified materials, is material because it goes directly to the core questions the grand jury is trying to answer. If prosecutors can prove Patel made false statements under oath about any of those topics, they can charge him with perjury. Each false statement is a separate count, and each count carries up to 5 years in prison. So if Patel lied about 3 different things during his testimony, he's looking at up to 15 years. That's not a slap on the wrist. That's a life-changing federal prison sentence. And contempt is even more immediate. If Patel had refused to testify after receiving immunity, the judge could have held him in civil contempt on the spot and ordered him held until he agreed to testify. That's not a trial. That's not a conviction. That's a judge using inherent authority to enforce a court order. And Patel would sit in a cell until he decided to cooperate. No bail, no appeal bond, just jail until he talks. That's how serious contempt powers are. That's why immunity is such a powerful tool. It removes the shield and leaves witnesses with 2 choices: talk or go to jail. Now, Patel did testify, so contempt isn't currently an issue, but perjury remains a massive threat hanging over his head. Every answer he gave in that grand jury room is now part of the record. Prosecutors will compare his testimony to every document, every email, every text message, every other witness statement they have. And if they find contradictions, they'll present those contradictions to another grand jury and ask for a perjury indictment. And once indicted, Patel faces trial where prosecutors will present evidence that he lied under oath, and the penalty for conviction is federal prison time. The broader implication for Trump's legal situation is that prosecutors are systematically dismantling the wall of silence that protected him for years. One by one, the people who were in the room, who saw what happened, who heard what was said, are being brought before grand juries and forced to testify under immunity. And their testimony, even if they try to minimize damage to Trump, is building a comprehensive picture that prosecutors can use to prove their cases. Patel is just the latest in a long line of Trump insiders who talked tough on television and then folded under oath when faced with real legal consequences. Michael Cohen folded. Mark Meadows folded. Multiple White House lawyers testified. Personal aides cooperated. And now Patel has been compelled to testify under immunity. The pattern is unmistakable, and every new witness who testifies makes it harder for the remaining holdouts to maintain their silence, because prosecutors now have sworn testimony from people inside the inner circle. They have documents, they have recordings, they have timelines, and they can use all of that evidence to impeach anyone who tries to tell a different story under oath. So while the YouTube videos with dramatic titles and fictional courtroom meltdowns are explicitly labeled as entertainment, the real situation is genuinely terrifying for anyone in Trump's orbit who thought they could avoid accountability through loyalty or silence. Patel has already been dragged into court and forced to testify after prosecutors stripped away his Fifth Amendment shield. Legal analysis stresses that if he ever defies a clear court order or lies under that immunity, a judge could indeed use contempt powers, including jail, to compel compliance or punish perjury. Multiple viral clips contain disclaimers stating their content is fictional, but the real danger is that Patel's own prior statements can now be turned against him in court, with judges and prosecutors comparing his old rhetoric to his sworn answers and catching him in contradictions that could form the basis for perjury charges carrying serious prison time. For Trump's orbit, Patel is a test case showing what happens when a fiercely loyal ally gets boxed in by immunity and the threat of contempt. And other insiders watching his situation may decide that cooperation is safer than risking jail over evasive answers that judges won't tolerate. The high drama of final warnings and faces jail in those viral videos reflects genuine legal stakes because under immunity, Patel no longer gets to hide behind the Fifth. So if he stonewalls or lies, contempt or perjury charges are real risks that could land him behind bars. One bad answer under oath. One contradiction between public statements and grand jury testimony. And a judge's contempt power becomes very real, with potential jail time that Patel can't avoid through political connections or loyalty to Trump, who ultimately can't protect him from judges enforcing their orders and maintaining the integrity of the judicial system. The trembling evidence is all there. His own words, his own claims, his own public performances. And now those words are being held up next to his sworn testimony, and the legal system is measuring the distance between them. If that distance is too far, If the contradictions are too stark, if the lies are too obvious, then Patel doesn't just lose his reputation. He loses his freedom. The judge's order is signed, the immunity is granted, the testimony is locked in, and the only question now is whether Patel told the truth when the cameras were off and the oath was on. Stay tuned, because the grand jury transcript is sealed, but the consequences are coming, and if prosecutors found what they were looking for, the next time you see Kash Patel, it might be through the glass partition of a federal visiting room.